Hello, I am Lisa Eshelman, an attorney and commissioner with the Ohio Environmental Review Appeals Commission.
And I am Kurt Hunt, attorney with Dinsmore and Scholl, and we are the case committee chairs of the 2012 Ohio High School Mock Trial Case Committee. This year, the Ohio Center for Law-Related Education presents to you State of Ohio versus Storm Jackson.
In this year's case, a college freshman is accused of stealing prescription drugs while attending two real estate open houses and while visiting at the houses of two friends. The defendant, Storm Jackson, and his parents' name were on a sign-in list at both of the open houses. Without a warrant, the Glen City Police Department subpoenaed and obtained Storm Jackson's cell phone GPS records, then arrested him. Storm Jackson has filed a motion to suppress, claiming that the evidence seized was the result of an improper search and seizure that violated his Fourth Amendment rights.
The state of Ohio is the plaintiff in this lawsuit. The plaintiff will argue that Storm Jackson's motion to suppress should be denied because no Fourth Amendment search took place with regard to his GPS records. The state's position will focus on these arguments. First, Storm Jackson had no subjective expectation of privacy in those records. Before receiving his cell phone from Spryzen Wireless, Storm signed his cell phone contract, in which he expressly consented not only to the collection of his location data, but also to Spryzen Wireless' potential disclosure of that data to law enforcement. Second, even if Storm Jackson believed that his cell phone GPS records would be kept secret, it is not a belief that society recognizes as reasonable, because a person has no legitimate expectation of privacy in information he or she voluntarily turns over to third parties. Third, Storm Jackson was subjected to no unconstitutional warrantless search in this case. Storm Jackson's cell phone GPS records were merely a proxy for his visually observable location as he moved about on public roadways and upon the premises of the four houses from which drugs were stolen.
The plaintiff will bring to court two of the three following witnesses. Peyton Thurber is a detective with the Glen City Police Department. Detective Thurber will explain that the local police department uses GPS technology to assist in solving crimes and that it does not require a warrant to obtain and use the GPS information. Detective Thurber will recount how he or she received reports of 4 different prescription drug thefts on Monday, June 27th, and how, based on the witness interviews and the GPS information, Detective Thurber was able to obtain an arrest warrant for Storm Jackson. Shannon Gannon, an associate with Spryzen Wireless, will explain how GPS technology has evolved and that Spryzen's equipment can precisely locate a GPS-equipped device within 30 feet of accuracy. Additionally, Shannon will testify Spryzen uses the GPS data for scientific and marketing research and other purposes. However, Spryzen's policies require cell phone users, such as Storm Jackson, to consent to the use of GPS data. Because Storm Jackson gave consent, Shannon was able to provide Detective Thurber with the requested information without a warrant, according to Spryzen policy. Finally, Drew King, a real estate agent with Glen Distinguished Homes, will confirm that on Sunday, June 26, 2011, Storm and Mr. and Mrs. Jackson all attended 2 different open houses in Glen, Ohio, as evidenced by their names being on the sign-in sheets. Following the open houses, King received phone calls from the owners of both homes. Both owners told him that prescription drugs were missing from the homes after the open houses. The following morning, King placed a call to Detective Thurber to report the incidents.
The defendant, Storm Jackson, is challenging the use of the GPS evidence in court through a motion to suppress. The defense will argue that Jackson's motion to suppress should be granted because the Fourth Amendment protects GPS information obtained from the defendant's private cell phone. The defense will focus on these arguments. First, that Jackson purchased cellular service, not surveillance, from Spryzen, and expected the information derived from that service to remain private. Second, even if Jackson should have been aware that Spryzen was collecting GPS data by virtue of the cellular service contract, the average user would assume that the data was being collected for phone company purposes, such as billing or marketing reasons, not law enforcement purposes. Third, Some of Storm Jackson's movements would certainly have been exposed to the public during this time, but no one, including Jackson, expects all of their movements over such an extended time period to be exposed to the public.
The defense will bring to the court 2 of the 3 following witnesses. Quinn Ruby, a telecommunications engineer and GPS designer, will testify that GPS signals can be inaccurate due to weather, tall structures, and interfering signals from other wireless devices. Additionally, even in the absence of these issues, GPS technology is just not advanced enough to pinpoint a device to within feet or inches. Sammy Delane, a parent at one of the homes where a theft was reported, will confirm that Storm Jackson was one of the friends visiting the home that evening, but he or she will also provide details into the relationship of Storm and his or her son, Bruce. Delane will report that Storm has continually been a source of support for Bruce throughout his battle with osteosarcoma and has done nothing but help him through his illness. Finally, the defense may call Jaden Fitzgerald, senior counsel for the Electronic Information Privacy Group. Fitzgerald will explain that research shows that most people believe that GPS data is private and should not be shared without consent and knowledge. Research also shows that people believe that tracking cell phone users' movements without consent is an invasion of privacy.
Your job is to present the strongest evidence and the best legal arguments that can be offered on one side or another in the hypothetical factual scenario provided in these case materials. The attorneys who have prepared the case materials have based this case upon actual court decisions, with an eye toward framing the facts of this case in a manner that is evenly balanced between the arguments of the plaintiff and the defendant. You should not rely on any court decisions or other legal information beyond that provided to you in these case materials.
The Ohio Center for Law-Related Education and the Case Committee for State of Ohio v. Storm Jackson hope you will find this case challenging and thought-provoking. It is our hope that this case will give you a greater understanding of the Fourth Amendment to the United States Constitution.
It is also our hope that all who participate in the high school mock trial competition will have a great experience, and we want to take this opportunity to go over with you a few brief competition reminders. It is expected that advisors, coaches, and parents will at all times model civil behavior towards and respect for the court and members and supporters of the opposing team. Also, please remember that the competition coordinators and judges are volunteers who have taken time out of their schedules to participate in this program. Understand, as it is in authentic trial situations, that judges may demonstrate different degrees of preparedness and may make rulings at their discretion that the parties may not always agree with or like. We urge the mock trial participants to be flexible and understanding throughout the competition process.
Best wishes and good luck.